3 amended traditional motions for summary judgment by pay and save and 3 responses against plaintiff Finkley. There were some against Masita. Then the most recent motions were motions for summary judgments, no evidence. Correct. And that's the notice of hearing plaintiff received, a no evidence motion for summary judgment hearing. But in any event, the arguments in the traditional motion for summary judgment, the last one being filed in May of 2023, are basically subsumed in the no evidence motion for summary judgment. Same arguments, essentially. In regards to plaintiff's oral argument today, you should have a binder and binder titled Plaintiff's Response in opposition to defendant's no evidence motion for summary judgment. So that's probably the big one. That's probably the big one.
Yes.
So that's the one we'll be going through today, Judge, the no evidence response, and it applies to the traditional as well. Judge, and first I'd like to respond to the negligent activity. Defendant is Mr. Lyle is correct. On page 33 of plaintiff's no evidence response, we've essentially said we agree regarding the negligent activity, negligent hire and training. Summary judgment should be granted for those. After evidence, there's no evidence of a contemporaneous activity. So we stated that specifically in our response, so that can be done away with. So we don't need to spend time on that, Judge. So I'll be going through Mr. Lyle's, or responding to Mr. Lyle's no evidence motion for summary judgment against plaintiff. And to do so, I'd like to focus first on the control issue, because as Mr. Lyle said, for his argument, that is the crux. The crux is whether or not he had control. And Mr. Lyle bases his argument essentially in its entirety on the contract, a contract between him and EP Samana, a contract between landlord and tenant. And Pay and Save is essentially saying there was no duty to Ms. Finkley, who everyone has admitted thus far was an invitee of Pay and Save on the date of the incident. How do we know that? She walked into the Pay and Save store, bought Pay and Save groceries, put them in a Pay and Save shopping cart, paid for them at the Pay and Save, and as she's walking out of the Pay and Save with her Pay and Save shopping cart, Pay and Save receipt, Pay and Save, Pay and Save, Pay and Save, she's still an invitee and she's headed towards her vehicle that's parked in the parking lot. And that's when the incident happens. And what happens is it's a large enough, we'll call it a hole. It's just a large, that's what plaintiff called it, a hole where her tire gets stuck in it. And she says she was shopping for Thanksgiving, so it's full. It's a full shopping cart, Thanksgiving shopping cart. Hits the hole, causing her to fall over, in the end, resulting in 2 knee surgeries. That's what happened. So plaintiff is an invitee. The issue here is not just that of contractual duty, because I think we'll all agree there was no contract between Ms. Finkley and Pay and Save on the date of the incident. What we have here is a common law duty to an invitee, Ms. Finkley. There may be no contractual duty because that contract is between landlord tenant. But the question is there a common law duty on this date in this area to Ms. Finkley? So some additional, Mr. Lyle covered most of the facts. One important fact that we'll get into, Judge, but I would like to not gloss over is page 5 of plaintiff's response. And page 5 basically shows the hole. There's several pictures. There's pictures on the date of the accident. We only had those in black and white. There's pictures produced by the defendant, I guess a couple weeks later, that were produced. And then there's pictures taken later per an investigation. And a juror can, and the judge can look at those pictures and see that it's essentially the same hole. But this will be important. The size of the hole, the depth of the hole, the fact that it's large enough for a wheel to get stuck in it will be important later as we see based on some of the case law. Mr. Lyle did touch on a couple statements made by both the corporate representative for Pay and Save, Joel Griffith, and the store manager's testimony of Pay and Save, and both of them said essentially the same thing. And this is on page 6 and 7 of plaintiff's response. And I've taken the transcript there. And essentially what they said is, even in the common areas, they expect their employees to have common sense and report to the manager any unreasonably dangerous conditions they see. Even in the common areas. That's what the corporate rep said. And that's what the store manager of EP Semana said. The store manager that was manager at the time of the incident and that's manager today. They expect their employees who are in the parking lot, because they maintain a presence on the parking lot, if they see an unreasonable dangerous condition, exercise common sense and report that to the manager so that it may be reported through an internet system, a help desk where the manager has a button and can just push, "We need help, landlord. Come fix this." Okay. And Mr. Lyle touched on, in the past, defendant did this. Pay and Save did this. They clicked the help button regarding different conditions, dangerous conditions in the parking lot. One was a ballard, a pillar, the one that stops people from going into the store with their car. It was knocked over. That was in a common area. This is page 8. The tenant, Pay and Save, clicked the button, let EP Semana know. In regards to the parking lot being restriped, in regards to lights in the parking lot needing repair, they notified EP Semana. So let's jump to the control issue. Those are just some facts that I wanted the judge to hear as we go into the argument. In regards to the elements of a premises liability case, the first element is that the owner or occupier had actual or constructive knowledge that a condition posed an unreasonable risk of harm. So the first thing I'd like to talk about there is the occupier, whether or not, because that's a question, whether or not Pay and Save was actually an occupier, had control of this area of the common areas. That's a question. That's what Mr. Lyle says is the crux of the issue here. Well, what we see, and I'm going on to page 11 of plaintiff's response, is that Pay and Save, through deposition testimony, admitted that they occupy the store, the Food King there. They occupy the store. They admitted that it's foreseeable and that they understand that their invitees, their customers, would park in the parking lot, utilize the area where plaintiff fell, pushing a shopping cart. They said they understand that that could happen. They also admitted that if there is a repair that needs to be made in the common area, they pay a pro rata share. And that'll be important later. They pay for a part of it. EP Semana doesn't say we'll pay for everything. They pass that on to the tenant, being Pay and Save and the other individuals there. So in the end, we'll see that finally, I believe this year maybe, or last year, the hole was repaired, and that payment for that, part of it was paid by EP Semana. And we'll see that that has to do with control. They had control because they had the responsibility to pay in the end. Okay. They admitted that they have a pro rata share Responsibility. Mr. Kim showed that to you on the screen where it said they have the duty to pay for it. They Pay and Save admitted that on the date of the incident, even though the groceries fell all over the sidewalk and in the common area, Pay and Save employees helped Ms. Finkley, an invitee, picked up her groceries, even the broke runs, cleaned up the area because it wasn't safe. There was glass and stuff. Had Ms. Finkley go inside the store, and they reimbursed her for the incident that was caused by the dangerous condition of the parking lot. So today they're saying, hey, it wasn't our fault. We have no duty responsibility. But on the date of the incident, they replaced all her items for an issue that happened in the parking lot. And then finally, in regards to the question of control, as we just heard, there was testimony where store manager and corporate rep expect their employees to look for unreasonable, dangerous conditions in the common area and report those conditions in the common area. And this is important because control. According to case law, control can be proven by either a contractual agreement or an actual exercise of control. See, that's the crux of the issue here. Mr. Pay and Save and Mr. Lyle want you to focus on the lease agreement. But case law says not only it can be proven by either the lease agreement, but it can also be proven by what actually happened, real life facts. And if those real life facts create a fact question, the question for control goes to the jury. And in the end, Pay and Save can ask the jury, did we have control or was it EP Semana? And the jury should be able to answer that question. There's even case law that says a non-owner who controls the property owes the same duty to the entrants or invitees on the property as the owner. So there's case law that the case law isn't clear. It doesn't say, oh, the lease agreement says you don't have any duty on the common area. I guess you're absolved. No, the case law, as we saw in Alexander, as we'll see in Cohen v. Landry, says if you assume some type of actual control, if there's evidence of control, that's a fact question for the jury. And that's what we're talking about here in a no evidence motion for summary judgment. Is there a fact question? Can reasonable minds differ? And the answer is yes. In Cohen v. Landry, so Mr. Lyle says that we put all our eggs into the Alexander basket. That's not true. That's not true at all, because besides Alexander, which I think applies here, there's a case, Cohen v. Landry's, and this is page 12 of plaintiff's response. And in that, the property owner who did not own an adjacent sidewalk where a fall occurred, because he paid for the repair or sought an estimate on the repair, the court said that that was a scintilla of evidence. That was enough evidence to show for a jury to decide whether the owner or here the occupier exercised control over the sidewalk. They said we didn't own it. That's the city sidewalk. They produced the deed, much like Mr. Lyle produced the lease. But there was evidence that on one occasion, even after the incident, they said, hey, how much will this cost to repair it? And the judge said, and the court said, that is evidence of actual control. That is evidence that should go to the jury so that the jury can determine, did they exercise control or not? But sufficient control to make them responsible. That's a scintilla. We have that evidence here today, and we'll go through that. Case law since 1986 has said, in most cases, control is a question of fact. That's page 13. Control is a question of fact. And I think it's because we're sitting here today arguing over little facts to decide whether there was control or not. And that's a question for the jury. Today, Pay and Save is asking you to take that question away from the jury and to decide it for yourself. But under Texas law, that has generally been a question for the jury. So in regards to control, let's look at what the lease agreement says, Your Honor. And the lease agreement isn't as clear as Mr. Lyle would have you believe. It's not as clear regarding control. It says exactly what the common area is and who will pay, but it's not as clear as they would have you believe. This is page 13 of plaintiff's response. For instance, section 6 of the lease agreement provides costs of common area and maintenance. And this is what we were talking about regarding pay. And essentially what it says is the expenses to common area will be borne by the tenant, here Pay and Save, and we will be billed to the tenant, Pay and Save, as an additional charge and cost. So in the end, who pays for this? Not EP Semana. In the end, Pay and Save pays. Landry's, in the Landry's case, Cohen v. Landry's, if there was a scintilla of evidence that in the end, the tenant had to pay, that may be actual control. That was their evidence here. Here we have evidence above and beyond that. Further, the lease says on page 6 of the lease, the tenant covenants and agrees to pay its proportionate share of the common area expenses. Again, they pay. Page 14 of plaintiff's response, page 6 of the lease. In all events, tenants shall keep the sidewalk areas, vestibule, and plate glass adjacent to its lease premises and its rear service area clean and clear of debris and litter. So in other words, Pay and Save would have you believe they have no duty, no responsibility regarding the common area. They can let happen whatever happens. That's not my fault. That's EP Samana. But the lease isn't as clear as they would have you believe. And it specifically says here they have some duty to keep it clean and safe and clear of debris. Sidewalks adjacent, near. So this is a big shopping center. And the nearest store to this sidewalk is Pay and Save's. Pay and Save is sort of on the right end. And then it's Pay and Save, sidewalk, and then a bunch of other stuff. Pay and Save's the only store next to this area. So that falls under this part of the lease. Second, Judge, page 14. Pay and Save had possession of the premises. Pay and Save admitted that after the lease, at some point, they put 4 cart corrals on the parking lot. They built cart corrals on the parking lot, and they admitted that they have to maintain and inspect and make sure those cart corrals are safe. Next, they admit that their shopping carts, which is their property, can be all over the parking lot. So they have employees maintain a presence on the parking lot to inspect, to make sure it's safe. Pick up any shopping carts that are there that shouldn't be there. They have possession. Well, they have possession and common law duty to their invitees that are going into the store and are leaving their store. Again, this isn't a contractual issue. Ms. Finkley wasn't part of a contract. She was an invitee here. They maintain a duty to inspect. In regards to the possession, we see that they have possession in what Mr. Benoit, the store manager, and what Mr. Griffiths testified that they expect their employees to do while in the common areas. Look out. If you see unreasonably dangerous condition, report it to the manager. That is evidence of possession. A reasonable juror can differ on that. And then whether Pay and Save assumed actual control. This is what we see in the Alexander case. This is what we see in the Cohen v. Landry's case. Did defendant in any way assume actual control of the common areas? And the answer here is yes. Again, page 16 of plaintiff's response, I'm going to point you to various printouts of the reports where Pay and Save called in issues in the parking lot to be repaired. That shows that they're inspecting. That shows that they know they can inspect. That shows that they know they have control. That shows they have the right to do that. And with rights come duties. So in all these in all those instances where they asked for a repair, what else do we know? They paid for that repair in the end, their pro rata share. So I'd like to jump now to, so that's the question of control, Your Honor. Those are the facts related to control. If Your Honor has any questions regarding to the control issue, I'll take those, or I'll move on to the next point, the unreasonable risk of harm, page 19.
You can move on, Mr. Bryson. Go ahead.
Thank you, Judge. So the unreasonable risk of harm. Here in this issue, we have to look at the whole and decide, did this whole pose an unreasonable risk of harm? Page 19, here's the case law. There's no definitive objective test that exists that may be applied to determine whether a condition presents an unreasonable risk of harm. When deciding something as a matter of law, usually you want a definitive objective test. And when it's a subjective issue, subjective issues are for the jury. Case law also states, this is the Supreme Court in McIntyre in 2022, the determination is typically fact intensive and therefore well suited for a jury's determination. The extent to which a condition is unreasonably dangerous is ordinarily a fact question. So this question of unreasonable risk of harm is a fact question. Page 20 has a picture of the hole. Again, there's several pictures. There's pictures plaintiff took on the date of the incident. There's pictures defendant produced, and there's pictures of an investigation. The question that a jury will have to answer is, does this pose an unreasonable risk of harm? And defendant wants you to take that question to yourself and say, no, I'm looking at the picture and it's not an unreasonable risk of harm. The problem is there's factors that need to be considered here. Page 20 has those factors. Was it clearly marked? What's its size? Did it previously cause injuries, generate complaints? Was it substantially different from other conditions? Whether it was naturally occurring. Not one of these is dispositive. That's why it's a factor test. So in regards to the size, this is the case. This is attached to the response as exhibit F. And not only is the court's opinion attached, but I attached the plaintiff's response, because the plaintiff's response had some pictures of what the court deemed to be not a dangerous condition. So you can see what a not dangerous condition looks like. And that's page 21 of plaintiff's response. And the important thing to note here is this is what Pansage is asking you to do. Look at the hole and say it's not dangerous. Well, this is very different from the McIntyre case. And in the McIntyre case, the court held that this hole was not dangerous, but because they held it was measured less than an inch deep. It was a tiny surface defect in the pavement. It was a divot. It was small and unremarkable, and it was profoundly ordinary for parking lots. Well, if you look at our hole here, it's large, it's not ordinary, it's deeper, and we compared the size. The hole in that was what? An inch, not even an inch. Our hole is approximately 3 to 4 inches deep, 4 to 5 inches wide. It was big enough for a tire wheel to get stuck in and cause it to fall over. So that question is not for the court. That question of whether it's unreasonable, dangerous is for the jury. And even Mr. Griffith, who's the corporate representative for Pay and Save, when he showed a picture, is this an unreasonably dangerous condition? His response was, well, it depends on the depth of it. Fact question. Here, it does. The jury gets to decide whether the depth of it, the size of it, makes it an unreasonably dangerous condition. Mr. Griffith couldn't even answer that question dispositively. It's a question for the jury. And plaintiff cited in page 22 and 23 for 3 different cases where the courts have found holes or divots of certain sizes to be questions for the jury. And that's in Cohen, a 1/2 inch to 1 inch, Walmart v. Alexander, a 5/8 inch ridge. That's important because they said, well, that's a fact question. A ridge that measures 5/8 of an inch, we'll leave that to the jury. That was the Supreme Court in 1993. And in Whalen, a 1/2 inch to 3/4 inch deep hole was left to the jury. Those were fact issues for the jury. Okay, so the next factor, was it substantially different? Page 23, I show some other cracks. This is an investigation by EP Samana, or an inspection photo, I'm sorry, from December of 2020, right before the incident, that EP Samana produced. And it shows that our hole is substantially different than the other holes or the other cracks or divots, whatever you want to call them, in the parking lot. This factor weighs in favor of question for the jury, unreasonable risk of harm. In fact, EP Samana's own corporate rep, when shown a picture of it, he testified on page 24 of our response, yeah, this is something that needs to be repaired. Is it fair to say that this condition, and then he also testified that he believes, or it's likely that condition existed before November 3rd of 2020. He believes that it existed for some time. And just looking at the pictures, you can tell that that's a condition that has existed for some time. That's a question for the jury again. did this condition exist long enough for a pay and save employee who's walking around the parking lot to decide, I need to report this, an issue for the jury. So there was another issue in Mr. Lyle's no evidence briefing regarding open and obvious, essentially saying, hey, that hole's big enough that the plaintiff, Ms. Finkley, could have seen it just as well as our employees could have seen it. And because it was open and obvious, according to Pay and Save, they have no duty to prevent the risk or remedy that issue or to warn. Problem is, they used Austin v. Kroger. And this is page 25 of plaintiff's response. Austin v. Kroger was an employee at Kroger who was mopping, slipped on the very area that he mopped at. He had just mopped and then sued a non-subscriber. Premises liability in the end, but it's a non-subscriber. And the court held specifically that, hey, when you're an employee and you're the one that causes the dangerous condition, you know of the condition and you have just the goodest chance as the employer to determine whether that's safe or not. That's not the issue here. First of all, we all agree Ms. Finkley was a business invitee. So we don't believe Austin v. Kroger applies here, because Austin v. Kroger stands for the proposition that if it's open and obvious, don't worry about warning. But case law, similar to the case here, says otherwise. And specifically, the Fifth Circuit held in Armendariz versus Walmart, this is page 26, there was a plaintiff pushing a shopping cart, and the court held that there was an open and obvious pallet sticking out. Plaintiff hit it, caused injuries. But the Fifth Circuit said whether that is an open and obvious condition is up to the jury based on these facts. The plaintiff testified that it was not open and obvious to her because she was pushing a cart full of stuff. And how do you expect her to see that pallet sticking out when there's a cart full of stuff in front of her? And the jury, the court in the Fifth Circuit said that's a fact question then. It may be open and obvious, but the question is, was it open and obvious to the customer pushing a shopping cart? And that question goes to the jury. I'm going to jump to whether defendant knew or should have known. Defendant is saying, Pay and Save is saying, we didn't know. We had no reason to know. It wasn't our job to inspect. But as we've already heard, Your Honor, they did inspect prior. They did have employees there. If they would have done a reasonable inspection, they would have notified the landlord. The landlord testified. If they would have been notified, they would have fixed it. And if Pay and Save would have done that, we wouldn't be here today. We wouldn't be here today. So the question as to whether defendant Pay and Save knew or should have known, I think just by looking at that hole there and knowing that they had employees, and there were 2 employees in the area where plaintiff fell on the date of the incident that ran to her immediately, they were standing right there. They should have known. Did Pay and Save fail to exercise reasonable care? They didn't do anything. They didn't warn. They didn't notify EP Semana. They did nothing. So there's no evidence that they did anything to try to prevent this incident. Did they? And then the last thing, defendant said there was no evidence that Pay and Save's breach of duty was a proximate cause. Well, she fell on the testimony is she fell on that date. And as a result of that, has had 2 knee surgeries. A picture of her knee is on page 33. What happened between the date, her knee surgeries, and the date of the incident? Nothing. It was the fall that caused that issue. Proximate cause. There's a fact question, at least for the jury to determine that question. That is all the plaintiff has for you today, Your Honor.
Gentlemen, I know could probably go quite a bit longer, but unfortunately the court does have to go to a board meeting at noon. And I know that Mr. Lyle, you have a response to the No, I can't go any further.
I know, Your Honor.
I have yet to review the written response in reply to plaintiff's opposition. And I am going to take those points on submission at this point. So if you have not, I don't know that I've received proposed orders in any form on all of them. I know some I have. So if you have not submitted those, please submit them via email. I'm going to tell you that we are starting a trial tomorrow. If that falls through, I will have a response for you by the end of the week. If not, we're looking closer to next Friday. And if you would like to request additional time for hearing, please do so with Ms. Hernandez. My apologies to you all for now. Again, if you want to request more time for argument, please do that with Ms. Hernandez. But for today, I have to adjourn this hearing. Know that if we're not in trial, I will be looking at this immediately. Okay.